Judgment in the appeal, Secretary of State for the Home Department and Franco Vomero.
The respondent, Mr. Vomero, is an Italian national. He met a United Kingdom citizen in France in 1985, and they came to England and married in 1987. They had 5 children for whom he cared in England. He had convictions in Italy, and he had further convictions in the United Kingdom between 1987 and 1999. In 1998, the marriage broke down and he left the family home. In March 2001, he killed Mr. Edward Mitchell. He was found guilty of manslaughter by reason of provocation, sentenced to 8 years imprisonment, and released in July 2006. In a decision made on the 23rd of March 2007 and maintained on the 17th of May 2007, the appellant, the Secretary of State, decided to deport Mr. Vomero under Regulation 21, subsections 2 and 3 of the Immigration European Economic Area Regulations 2006, giving effect to Articles 27 and 28 of EU Directive 2004/38. On a rehearing before a second immigration appeal tribunal in April 2008, Mr. Vomero succeeded in having the deportation order set aside, and on an appeal, the Court of Appeal dismissed the Secretary of State's appeal against that determination. A further appeal to this court was stayed pending the European Court of Justice's judgments in Onuquere, case C 378/12, and MG, case C 400/12, which are now available. The Supreme Court, having considered the position in their light, refers several questions to the Court of Justice for determination. Lord Mance, with whom the other justices agree, gives the lead judgment. Under Regulation 21, subsection 2, giving effect to Article 28, subsection 2 of the Directive, a member state may only deport a union citizen who has a right of permanent residence in its territory on serious grounds of public policy or public security. A union citizen has a right of permanent residence if he or she has resided legally for a continuous period in the host member state, and that period ending on or after 30th April 2006. See the Court of Justice decisions in the Secretary of State for Work and Pensions against LaSalle, case C 162/09, and Dias, case C 325/09. Under Regulation 21, subsection 3, giving effect to Article 28, subsection 3 of the Directive, a member state may only deport a union citizen who has resided in the host member state for the previous 10 years on imperative grounds of public security. The Immigration Appeal Tribunal and Court of Appeal treated Mr. Vomero as having acquired both a right of permanent residence as a result of 5 years continuous residence prior to the decision to deport him in March 2007, and a right to enhanced protection as a result of 10 years residence previous to that date. Contrary to the Court of Appeal's conclusion, the Supreme Court concludes, in the light of the Court of Justice's judgment in Onuquere, that Mr. Vomero had not acquired a permanent right of residence by the date of the decision to deport him. Onuquere establishes that a period of imprisonment cannot be taken into account in calculating the 5 years of continuous residence necessary for such a permanent right. As at March 2007, the date of the decision to deport, Mr. Vomero had spent over 5 of the last 6 years in prison. The question therefore arises whether a right of permanent residence is a precondition to the acquisition of enhanced protection after 10 years residence. The Supreme Court is not agreed as to whether this is clear, and the question will therefore be referred to the European Court of Justice. If their answer to this question is negative, further questions arise, to the answers to which are in the Supreme Court's view also unclear, and which should therefore also be referred to the Court of Justice. They relate to the calculation of the 10 years residence necessary for enhanced protection. The Court of Justice's judgment in MG indicates that the 10-year previous period may be non-continuous and may be interrupted by a period of absence or imprisonment. But whether the 10 years is to be counted by including or excluding any such period of interruption is unclear. It is also unclear what the true relationship is between the 10-year residence tests for enhanced protection, to which the language of Article 28, subsection 3 refers, and what has been described as the overall assessment of an integrative link, of which the Court of Justice spoke in MG, and which, in fact, in this case, led the Court of Appeal to conclude that Mr. Vomero enjoyed enhanced protection. The Supreme Court refers questions accordingly to the Court of Justice and will await the answers before addressing the appeal further.